Well, I came here today to say, as a man, that this is wrong, this is toxic.
This is an incredibly sensitive situation. If Jones, as rumor suggests, didn't follow proper procedures, such as providing formal written notice about the phone's use, then she may have failed a fundamental duty of care. It's not just about having an NDA in place. There must be a clearly worded policy stating, this is a company device, and anything stored on it can be accessed. Without that, any attempt to use the phone's data, let alone hand it over to someone else, could be legally indefensible. Even if she did have some limited right to access work-related data, distributing private material to an external party, or especially to Blake or the media, crosses a clear legal and ethical line. That act alone could be grounds for a defamation or privacy claim. It's interesting you mention Van Zam, too, because that brings up an entirely separate issue about how that shell company was allegedly used to funnel or disguise certain exchanges of information. If that connection is substantiated, it could seriously worsen the situation for everyone involved. On the very same day the lawsuit was filed, Jones allegedly warned a departing employee not to work with Abel, claiming her business wouldn't be around much longer, a statement that, at best, sounds threatening and at worst, hints at something far more calculated. The documents go on to describe what appears to be a deliberate strategy. According to summaries, Lively's team likely anticipated that major media outlets, such as the New York Times, would refuse to handle material obtained through questionable means, so they needed a color of law, a legal pretext, to legitimize the possession and use of those communications. Jones and her associates, meanwhile, seem to be seeking protection from liability, which may explain why the mysterious Van Zam shell company was inserted into the chain of events and is now named in the lawsuit. It appears to have been a way of distancing themselves from potential legal exposure, essentially an attempt to create a buffer between themselves and the questionable acquisition of private information. Given all that, I'm honestly shocked this hasn't become a bigger talking point in the broader coverage of the case. Final thoughts, Ron. Do you think this angle will finally start getting some serious attention? Or will Judge Lyman dismiss it as irrelevant? Well, I don't think Judge Lyman has much of a choice here. The lawsuits have now been formally consolidated, meaning this new case is directly tied to the broader dispute that began with Blake Lively's original lawsuit. Because of that, the judge will have to consider these allegations. They're undeniably connected and therefore legally relevant. What happens next largely depends on what Jennifer Ale chooses to do, whether she decides to push forward aggressively with these claims or whether she'll be pressured to settle. But either way, these developments can't simply be brushed aside now. The court will have to address the questions surrounding Van Zam, the data transfers, and the alleged misuse of private information, all of which go right to the heart of how far Team Blake and Team Jones were willing to go to control the narrative. If I were one of the attorneys on this case, my next move would be to push for discovery, to determine whether those communications were actually shared with Lively, how they were shared, and to whom Lively might have repeated them. That information would be crucial in deciding whether she and anyone else involved could be added as defendants in potential defamation or invasion of privacy claims. It's undoubtedly a complex process and a great deal of work. Litigation always is. But it could be well worth pursuing. I wouldn't be surprised if Friedman is quietly encouraging these steps behind the scenes, especially since discovery in this particular matter is still at an early stage compared to the other ongoing actions. There are clearly many moving parts here, and it's all starting to connect. As always, I appreciate you taking the time to join the discussion. Please make sure to follow Ron Zambrano and his team at West Coast Trial Lawyers if you ever find yourself needing top-tier legal expertise for a major case. And to everyone watching, don't forget to subscribe if you haven't already. We'll have Ron back soon with more insights as this story continues to unfold. Join us live tomorrow for a full breakdown of everything we've discussed today. Hit the thumbs up, share your thoughts in the comments to keep the conversation going, and stay tuned for much more right here on Popcorn Planet. Popcorn Planet. It's honestly unbelievable, Ron. I'm not even listed in the disclosures. Yet they're still coming after me, trying to pressure me into handing over information. And now they're attempting to override Judge Lyman's own rulings to change the time frame for when I'm supposed to handle conversations with my news sources. Are you surprised they're still using these kinds of tactics? And is that even right in your view? To answer your first question, no, not at all. When celebrities decide to push back, they often use their wealth and influence to hire lawyers who'll do whatever they want, regardless of fairness or principle. What's happening to you is deeply concerning because it creates a chilling effect. It discourages other people from reporting the truth, which completely goes against the purpose of the legal process. It's meant to protect justice, not silence journalists or independent voices. So no, I'm not surprised, but it's absolutely wrong. And Andy, this is something you can actually use to your advantage. You've said yourself, they haven't even identified you as someone with relevant knowledge or involvement, yet they're still pursuing you. That's a strong point in your favor, because it highlights how overreaching and aggressive their approach has become. Right, I hope that helps. And just to clarify, I misspoke earlier. Kirsty isn't on the list. There's been so much information coming through that I got it mixed up with another story. But what's really bizarre is that Taylor Swift is on there. They're somehow bringing her in as someone who supposedly has knowledge of the situation, even though Blake's camp has been publicly furious that Justin Baldoni mentioned her name at all. The hypocrisy and contradiction here are staggering. Speaking of strange developments, I wanted to get your thoughts on one more case before we wrap up, the ongoing matter between Stephanie Jones and Jennifer Ale. Jennifer has just filed her amended complaint, and from what I've gathered, thanks to Kim's notes, since so much of it is redacted, there's a lot to unpack. At the heart of it is the phone that was seized, Jennifer Ale's personal device, which contained text messages that were central to the original case. She's now suing Samantha Jones and others, claiming the seizure and use of that phone were improper. She argues that it wasn't a work phone at all, but a personal one filled with highly private communications, including intimate conversations about her marriage, her fertility struggles, and personal photographs. From an employment law perspective, how does that hold up? I mean, if the phone truly contained personal and sensitive material, and it wasn't company property, that seems like a serious violation, doesn't it? Exactly. All that material was being circulated not just by Jones, but also passed along to Blake, and apparently even to members of the press. It's now been formally entered as evidence in this ongoing litigation. But how on earth was that even permitted? Couldn't this seriously damage Blake's and Stephanie's legal standing? And considering they used a fake shell corporation, that Van Zam setup, shouldn't that raise red flags for the judge? Do you think Jennifer Ale has a genuine chance at finally getting justice here? Or is she effectively doomed because it's being argued that the phone was a work device, giving them free rein to use everything on it? How can this possibly be acceptable? Well, the moment you mentioned it, I immediately thought back to when we first met while filming the documentary out in the valley. I remember saying it was incredibly strange that they were in possession of someone else's personal phone. Here's the thing. When it comes to workplace devices and privacy law, there are very clear rules. If an employer provides an employee with a work phone or any electronic device, they must give written notice stating that the device is company property and that any activity on it can be monitored or accessed. The employee has to acknowledge this in writing. If that written policy existed and Jennifer Ale had signed it, then legally she was on notice, meaning she shouldn't have stored personal content on that device. However, even if that were the case, it doesn't give the employer, or in this instance, Stephanie Jones, carte blanche to use or distribute that information however she likes. There are still strict boundaries regarding privacy and proportional use. If Jones truly handed over the entire digital contents of AL's phone, including intimate conversations, personal photographs, fertility details, and private texts with her husband, and those files were shared directly with Blake Lively or her team, that's a serious breach of privacy. Based on the way the CRD, California Civil Rights Department complaint was drafted and quoted, it seems clear that a full digital image of the phone was taken and distributed. That's highly problematic. Even if the phone were technically company property, using its contents in this way, especially sharing them beyond the scope of the legal dispute, would likely violate both employment law and data privacy protections. None of that deeply personal material had any legitimate relevance to the underlying litigation. It's exactly the kind of overreach that could end up backfiring on Team Blake. And Team Stephanie if the judge views it as an abuse of process or a violation of privacy rights, if all of that material was simply handed over to a third party. That's a huge legal issue. It could easily amount to defamation and, without question, an invasion of privacy. If there was no prior consent or formal notice given before extracting and sharing that data, then Stephanie Jones is in serious trouble. And potentially Blake Lively as well. Here's why. When you're dealing with private information, especially personal communications or photographs, there are strict obligations around consent and confidentiality. If an employer intends to monitor or access an employee's device, they must explicitly notify them, usually in writing, that the device is for work use only, and that anything on it can be reviewed by the company. If no such notice existed, and Jones simply accessed and distributed the contents, that's a major violation. And if Blake or her legal team accepted that data without questioning where it came from or how it was obtained, they too could be implicated. Any reasonable person, especially an experienced professional, would have stopped and said, "Hang on, how do you have someone's personal phone records and private messages?" The correct and ethical response would have been to refuse to view or use that information until its source and legality were verified. If you read the headlines, you'd think Blake Lively had already won and Justin Baldoni had missed deadlines and lost completely. But that's simply not true. Joining us to clear everything up is Ron Zambrano. Welcome to Popcorn Planet. I'm Andy Signor, and I'm delighted to have Ron Zambrano back with us. Ron, first off, congratulations on your recent success. I heard you secured a huge 7-figure settlement for an employee whose manager had assaulted them. It sounded absolutely horrific, but well done for continuing to achieve incredible victories for victims who truly deserve justice. Thank you so much. It's always an honor to represent women who've been through such trauma. And while nothing can take them back to where they were before, it's rewarding to help them find some measure of justice. We're really proud of that work. I wanted to highlight your success because clearly you know this field inside out, especially employment law in California. I've been quite taken aback by how misleading the media coverage has been. From my perspective, they've twisted the story. I'd love your thoughts on that because outlets like TMZ have made it sound as though Justin Baldoni has accepted defeat, that it's all over, that he missed an appeal deadline after the judge's dismissal. People Magazine, Rolling Stone, The New York Post, Page 6, ABC News, they're all saying the same thing. Justin Baldoni lost. He failed to act in time. It's everywhere online, and honestly, it's shocking. But when you actually read the court documents and the judge's rulings, that's not the case at all, is it? The truth is, he didn't miss any deadlines. He still has the right to appeal. I think I understand it now, but could you please explain it clearly for the audience? So, under the federal rules of appellate procedure, specifically Rule 4, there's a process that governs how and when someone can appeal a case. Generally, in both federal and most state courts, it works like this. Once an order is issued that effectively ends a case for one of the parties, you don't immediately start counting down the appeal period. First, a formal judgment has to be entered. That means the judgment must be signed and recorded. The appeal clock doesn't actually start ticking until there's a notice of entry of judgment. It's admittedly a rather complicated, and arguably overcomplicated, process, considering what it's meant to achieve. But in essence, the rule of thumb is that the 30-day deadline for filing an appeal begins once the judgment is officially entered, not merely when the court issues its initial order. Now, in this specific case, the Judge Lyman, referred to a recent amendment to the Federal Rules of Appellate Procedure, which gives the court discretion to determine when the case becomes final for appeal purposes. He decided to hold off on starting that 30-day countdown until he has ruled on a separate motion. Namely, Blake Lively's motion for attorney's fees, which involves a substantial amount of money, reportedly in the hundreds of millions. Judge Lyman explained that, for the sake of judicial efficiency and clarity, the appeal window would not open until that motion for fees has been decided. In other words, there was no missed deadline, because technically the deadline hasn't even begun yet. The 30-day period to file an appeal won't start until Judge Lyman delivers his ruling on Lively's motion related to those fees. Until then, Baldoni is essentially just waiting. As it's clearly stated, and anyone can verify this themselves on page 205, before an appeal can be filed, the countdown to appeal only begins once the court enters an order resolving certain pending motions. In other words, if there's still a motion under consideration, such as one to amend or alter the judgment or to determine legal fees, that motion effectively pauses the appellate clock. In this case, that's exactly what has happened. The judge noted that the time to appeal runs for all parties from the entry of the order disposing of that motion, rather than from the entry of final judgment. So, the countdown hasn't even begun. It won't start until the court rules on Lively's motion for legal fees. The judge even spells this out clearly in his final paragraph. He writes, "It is therefore ordered." And under Federal Rule of Civil Procedure 58E, he confirms that Lively's pending motion for fees will be treated as such, and that the motion seeking partial judgment is denied as moot given the court's existing ruling. What that means, in plain English, is that Justin Baldoni still has every right to appeal. This case is far from over. And given that he's now brought on Alexander Shapiro, a highly respected appellate lawyer, it's fair to assume they have a clear strategy in place. It wouldn't make sense for them to rush anything right now. Appealing too soon can actually backfire. The appellate court could reject it outright, saying it's premature, because those courts are notoriously strict about timing and procedure. So, until the motion for fees is decided, the 30-day appeal window simply hasn't started. And let's be honest, these are extremely experienced, top-level legal professionals. If there really had been a deadline, they would have filed immediately. Filing a notice of appeal is quick and inexpensive, just a short form and a modest filing fee. The fact that they haven't done so yet is further proof that no deadline has been missed. The judge's order makes it clear. The clock won't start until he rules on the fee motion, full stop. Right, they still have time. What's really concerning to me, especially as someone still dealing with my own subpoena situation involving her, is just how the media swallowed this whole narrative without question. It's as if Blake Lively's PR team pushed out a single talking point, and every major outlet ran with it. Now there's this completely false narrative circulating online, with people saying things like, "Will all the creators who criticized Blake now apologize and admit they were wrong?" Of course they won't, but that's not even the point. The truth is, the case isn't over. We're still right in the middle of it. You've represented plenty of ordinary people standing up to powerful celebrities. Is this sort of thing common? Where big names use PR tactics to manipulate how the story is told in the media, rather than focusing on what's actually happening in court. Absolutely. It happens all the time. I won't name names, but it's very frustrating. The people around celebrities have a vested interest in maintaining that public image. Their careers, reputations, and income all depend on it. They'll pull every lever they can to control the narrative in their client's favor. For them, perception is everything. Even if the facts don't quite align, they'll spin the story to generate positive coverage because it strengthens the brand. If they can make the public believe their client is winning, investors and partners stay confident, projects move forward, and any damage to their image begins to fade. It's all about optics. But at the end of the day, Baldoni still has the right to appeal. And when that happens, what will they say then? "Oh, we got it wrong." Unlikely. Especially since, as we've established, the appeal window hasn't even opened yet. And honestly, it's unnerving to see just how much control they seem to have. I've seen the recently released list of initial disclosures, the document outlining who might have relevant information in this case, and it's enormous. It includes not just the defendants, but also high-profile figures and commentators like Perez Hilton, Candace Owens, Colleen Hoover, and even Kirsty. It's a sweeping list of names, showing just how wide a net they're casting. It's a reminder of how far-reaching these legal and PR battles can become when a powerful celebrity is determined to control the narrative.